Welcome to IT as Management and BCS Specialist Group, BCS Law Specialist Group webinar with title Code of Conduct for Software Audits. I am Panagiotta Karadimitriou. I'm the BCS Law Specialist Group Secretary. And without further ado, I will introduce you to our today's speaker, David Eastwood. David is a Senior Managing Director at FTI Consulting in London. He has 38 years of experience, mostly as a forensic accountant, working on investigations and giving expert evidence on liability and quantum. David's areas of expertise include software and technology licensing and contractual rights of audit. He has been responsible for many thousands of software audits on behalf of major vendors, as well as projects for software customers looking to better manage their IT assets and audit risk. He works for both customers and software vendors. A bit about the content of today's presentation. Almost all software licenses include provision for the audit of the customer by the vendor to check whether usage is in compliance with the licensed rights. Globally, there are thousands of such audits every year conducted by software vendors and by third parties on their behalf, and billions of dollars change hands as a result. David will guide us through with his presentation in this interesting topic. The floor to David. Thank you very much from my side, and David, the floor is yours.
Thank you very much, Jota, and thank you to you and to Kylie and Sam Da Silva, CMS, for setting this up. In terms of my background, I think Jota's just given you an idea, but as regards this topic of software licensing and software audits, I've been working in this space for about 23, 24 years, and primarily initially for software vendors, but then increasingly for customers. And then over the last 4 years or so, focusing on more contentious aspects of that, where software licensing has come to court or into arbitration. And I have also been subject to an audit as well. So I have actually seen this, I think, from almost every direction. I'm going to talk a little bit tonight, obviously, about the draft code of conduct, and I'll introduce that and explain some more about it. I want to give you an idea of the background to that and of the thinking behind it and what we were trying to do and some of the parameters we set ourselves. And then I'll go through some, not all, of the obligations that the code seeks to place on customers, on publishers, and on the auditors. And then talk a little bit about the feedback we've had, because the code is currently in draft and we've sent it out for consultation. It's publicly available, and I put the link into the chat here. And I encourage you very much to look at it, perhaps as we go. But the idea is to talk a little bit about the feedback we've had. It's been out for about 3 months, and I'll give you an idea where that's coming from and what happens next. I'll probably talk for about 40 minutes, thereabouts, and I hope that will leave us plenty of time for questions. It's a topic that lots of people feel quite strongly about, and I'm very happy to debate, and really keen to get views on both the principle of the code and indeed on some of the detail as well, so that we can bear that in mind as we seek to move it forward to a later draft. So just in terms of a very high level, the draft code was pulled together by myself with 2 colleagues, Andrew Jackson and Gareth Coffey at FTI, also previously at KPMG, actually, for many years together. And the aim, very roughly, is to set out, if you like, what a software audit is, and draw some boundaries as to what is and is not sort of generally accepted market practice. The hope was to, or the aim was to provide a sort of baseline where everybody who's involved in this space can sort of reach a consensus view of what, as I said, is and is not accepted market practice, because that then provides a foundation for improving and developing that further for the future. But without that common language or common understanding, it's very hard to change things. And one of the observations and the things I feel strongly about is that, having been doing this for 23 years, in many ways, the landscape and the dialogue in this space has not changed substantially at all. And it seems to me long overdue that there should be a real effort to professionalize that landscape and to find a way to move it forward for the benefit of everybody in that space, but particularly for customers and for the publishers as well. As a starting point, I wanted to clarify what we mean by software license audits and what we don't mean, because I found this sometimes confuses people a little bit. So for the purposes of today, what I'm talking about is audits under the terms of a license agreement where a software publisher seeks to check that its customer, the licensee, has used its licenses in accordance with the license agreement. So it's the publisher's right to inspect or review or audit, whatever term you want to use, the customer. And it's important to bear that in mind and to differentiate that from a number of other types of audit that float around in the market as well, and which are importantly different. And some of the ways in which they're different we'll explore later on. So the first of these is the audit rights that a customer might have in relation to, for example, the security controls and other aspects of delivery by a cloud service provider. So that's a customer's right to audit the service provider. There's another type. A customer might also have rights to audit the service provider in relation to controls and governance, because it wishes to convey to its financial auditors that there is adequate confidence in the controls and governance that affect the information going into their financial statements. So that's a different type of audit. But again, it's a customer audit of a service provider. We then have the rights that a licensor, a software vendor, might have over a reseller or distributor of its software to go and check that, for example, it's receiving the correct royalties. We're definitely not looking at that one. And then there's another one that touches on this space, and that's the investigations or the audits that might be done by a publisher looking at an organization that is using pirated software. So in other words, there are no contractual rights at all, but an organization has found access in some way to the software code, has downloaded it, and is using it without any license at all. That again is just different from what we're talking about, because what we're talking about is a contractual right. And of course, in a pirated software case, there is no contractual right. So we'll come back to some of the differences between these a little bit later on. But just to reiterate, we're talking here about the publisher's right to inspect a customer. But it is interesting to be aware of these other ones because there is so much more structure and codification around audits by customers than there is of audits of customers, and they take place very differently. And some of the ways and some of those differences, I think, shed light upon perhaps the future direction of publisher audits of customers. So having established that that's what we're talking about, why do we think a code is necessary or desirable? So first up, some context for that. So a moderate sized customer can have 100 or more software providers. Being subject to 2, 3, or 4 audits by software vendors simultaneously is not that unusual. The elapsed time for an audit is between 3 and 18 months, say, and they fall outside those as well, but roughly 3 to 18 months. And there are tens of thousands of audits taking place every year globally. Most audits give rise to some sort of finding that a customer does not have quite the licenses that it needs for the use it's making, and for which the publishers expect to be recompensed. In other words, in most cases, the result of an audit is that a customer needs to purchase some additional licenses. I say most cases, somewhere between 60 to 80%, I expect. Mostly, the findings are relatively small. Certainly in terms of settlement, for a moderate-sized company, it's not unusual for findings to fall in, let's say, the $250,000 to $750,000 band, give or take.
David, just an observation from Ayota here. Could you change the slide? We are still in the first. So.
Yep. All right.
Yeah. Thank you.
It won't tell you very much, but we'll come on. We're leading to this. But although most settlements are relatively small and in broad terms easily absorbable by a moderate-sized company, there are findings substantially larger than this, and it's not at all unusual to hear of audit findings of $50 million, $100 million, $250 million. I think the largest I'm aware of was about $980 million. Those are findings, not settlements. But settlements are obviously much, much smaller than that, but nevertheless, big sums and still painful. Large numbers like these are very easily bandied about, and it's easy to over-egg the extent of the concern. But it's true that billions of dollars change hands as a result of audits every year from customers to software vendors. But for customers, there's next to no consistency between software vendors as to, for example, who does the audits and how the audits are done, what sort of information is looked for, how it's looked for, what sort of tools are used to collect it, and so on. This makes it very, very difficult for customers to prepare for audits and to manage them. And as I said, 2 or 3 running simultaneously is not unusual. So in broad terms, from a customer's perspective, you have a risk that is potentially a quite significant value, unbudgeted, of course, and hard to manage and somewhat capricious. And customers, quite reasonably, don't like that very much. Nor particularly do publishers either, or the software vendors, because yes, they have a need to protect their intellectual property, and yes, audits do, all in, generate significant sums of money for them. But it costs a lot to run an audit program. What money comes in should, by definition, have come in earlier, because a customer that's compliant would have bought the licenses that it needed before it had to be audited and chased down for them. But more particularly, software companies are acutely aware that the audit process harms, or at least threatens to harm, customer relationships. And so many people in the software companies are distinctly nervous about that and don't like it, frankly. So making audits work better benefits both customers and publishers. And I've given some of the benefits on each side on this slide here. One of those, from a customer point of view, is an audit does actually help understand what your license position is and what you have, and it gives a firm indication of that, which is a good thing. And a code would create greater certainty and greater consistency, which I think would significantly be to the benefit of customers. But the real benefit is greater transparency and increased trust in the relationship between publishers and customers in both directions. So let's just come back to the parties that we're talking about here. So we have, of course, the publishers, the customers, and the auditors. And the code sets out some obligations in relation to each of those groups. But there are other parties involved in audits, typically, so-called audit defense consultants, but also IT service providers, people of software asset management, providing software asset management services, and so on. And all of those may have practical obligations under the code as participants in this marketplace on behalf of one or the other parties. I wanted to give a little bit of idea before we dive into the specific obligations as to some of the thinking around the code and the parameters. So firstly, we took the view that the code had to be subordinate to the contractual terms. The code is in no way intended to change the contractual position between the parties. We felt that was just too big an ask. It creates too many barriers on both sides to put a proposal like that forward. And it's also extremely difficult, if it has any sort of legal significance, to make it globally applicable given the variety of jurisdictions and so on. And our ambition, modestly, was for this to be globally applicable. So we stepped away from any sort of direct legal significance for it, and to make it subordinate to those terms, and in effect, a voluntary arrangement. Our starting point for the content was the topics that usually get discussed in what are called kickoff meetings at the beginning of an audit. So these are usually held when the audit starts between the publisher, the customer, and the auditors, possibly others. And they're necessary because audit clauses don't spell out what is practically necessary on both sides to make them effective. A typical audit clause is about 175 words, something like that. Some of them are shorter, and the shortest is about 8 words that we've seen. Some of them run to 200 or 300 words, but they're never going to spell out the real details of what is actually needed to make them effective. So there is always a kickoff meeting to explain that. And that provided a starting point for what we put forward as the topics on which we should be agreed between the parties. Essentially, the code is trying to set out how a good audit should proceed. It's not seeking to set a floor. It's not the lowest common denominator. We've tried to set the topic somewhere between market practice and where we think market practice should be. We also confined ourselves to the process of establishing the license position, so the audit itself. And we avoided, therefore, questions of how any findings are resolved and settled. That's been the subject of some of the feedback, and we can talk about that a bit later on, but that was a very conscious boundary. We wanted to finish, if you like, with the provision of an agreed or potentially agreed summary of the licenses necessary, and then to leave the settlement and resolution of those outside our scope. Equally, at the other end of the process, we started at the point in which the audit is notified. So we've not addressed some quite interesting topics. So what customers should do to manage their software licenses and to prepare for audits, nor have we considered what software vendors could usefully do to help customers. Both of those are worth addressing, but we deliberately ruled them out of the scope for present purposes. We also ignored some previous efforts. So the previous efforts to draw up codes, such as they are, tended to be put forward by customers or groups of customers without the involvement of vendors primarily, and to my mind have been somewhat one-sided. And our view is that if there's any chance for the code to be adopted, it's got to work for all the participants. So a proposal that is inherently designed to favor customers or favor software vendors isn't going to fly. It has to find a middle path. We see the code as something that would be offered in effect by vendors at the time of audit notification. So essentially, when a customer receives an audit notification or letter, the vendor makes a promise to follow, if you like, best practice, to follow the code, provided that that offer is reciprocated by the customer. For that reason, particularly grateful for early feedback from a number of vendors about the direction and intent of the code and the detail. Enough feedback from vendors for us to be confident that it will be possible to find a form of words in the code which will be acceptable ultimately to both parties in due course. That is our ambition for later this year. So with that sort of preamble, I wanted to turn to look now at some of the obligations of the code on each of the publishers, the customers, and the auditors. and some of the others engaged in the process. What follows is the highlights, if you like. There are more obligations than I can reasonably cover here. So I think we probably have slightly over half of them. And I've also paraphrased them a little, so the detailed drafting is not here. Again, if you go to the link in the chat, you can find the draft code. But I hope that what follows will give you a flavor of what we're talking about and some of the underlying thinking. And we can then turn after that to the feedback and some of the discussion points. So starting with publishers. So roughly, these obligations follow the course of an audit. So the starting point is that customers should be notified in writing, referencing the audit clause in the license agreement. That might seem startlingly obvious in a way, particularly bearing in mind that the code applies to audits. So the starting point is always going to be some sort of audit invoking the audit clause. But we wanted to recognize that in the market, sometimes things that might be called audits might be described as reviews, or something might be proposed other than the formal exercise of the audit rights. And you do see that a little bit from some vendors and generally around the market, where a customer is invited to participate in something which isn't strictly an audit, but probably feels to the customer like an audit, but is described as voluntary or self-audit or review or something. So we wanted to be clear that an audit starts with invoking the audit clause. Usually, of course, there will be auditors. Sometimes the auditors are third parties, and sometimes they are employees of the software company, in-house, if you like. We wanted to treat the two as subject to the same obligations effectively. So here we're talking about the qualifications set out in the audit clause. And examples would be a clause that said the auditors had to be certified public accountants or a Big Four firm or an independent accounting firm of some sort or other. It's important that the auditors meet those obligations, or meet those definitions, if you like. One of the phrases that occurs a lot in audit clauses, but far from all of them, is that the auditors should be independent. And I think that's an interesting area for discussion because it doesn't seem to me that there is a clear consensus in the market as to what exactly is meant by independent in that context. It's also worth bearing in mind that audits, the use of third parties or in-house is not quite as binary as it might appear. And some software vendors have approached audits where, for example, auditors have gone in to establish the use of licenses, so the IT architecture and so on, but then that information has been passed to an in-house team, which has then done the job of comparing the license entitlements and so on. So you sometimes have a sort of half and half type audit approach, and it's important, obviously, that that is understood by the customer. Publishers should define the audit scope. So, for example, is the audit of an entire global organization, or is it just of a UK or a US or a European entity, or whatever it may be? Sometimes audits might be expressed in terms of a business unit or even a particular product. Mostly they're not, but it's important that the publisher defines that audit scope and that the customer understands that. It's important that the publishers identify the person responsible for the audit and agree some sort of escalation process so that the customer has someone to whom it can appeal in some reasonable way. That could be through its sales and account process, but there might be an escalation path in the audit team or the compliance function as well. And I think that's an important opportunity and certainly something to be clarified. A topic that has been much debated is the code's view that publishers should provide license entitlement records to the customer at the beginning of the audit. We'll talk a little bit about this because it's come up in the feedback, so I'll touch on it at the end. We thought it important from a transparency point of view that a customer should be clear about the entitlements that it's being assessed against and what it is allowed to use and the quantities of licensing that it has available to it. It seems to me entirely reasonable, therefore, that the software vendor should make that information available. But it is a slightly trickier topic than it first sounds. Nevertheless, the code requires it. Moving on, still with publishers. It's obviously right that the customer's information should be protected in the hands of the software vendor, and that will be covered usually by the license agreement in any event. But from a customer's perspective, the auditor, if it's a third party, is a stranger, as it were. So it's entirely fair that the customer should look to make sure that its information in the hands of an auditor is properly protected by an appropriate NDA. Either that or the publisher provides the same protection. Another thing that I think should be pretty obvious is that the publishers should be sensitive to the needs of the customer's business. Audit clauses often talk about not disrupting the customer's business, or phrases of reasonableness and so on. But it's very important for the publisher and the auditors to recognize that there are pressures on the customer. Audits take time and resources. They don't normally carry spare capacity in their IT departments. And for example, if you're a retailer in the run-up to Christmas, then you simply may not be able to handle having an audit process going on. There may be issues about change control and change freezes that would affect any tools the auditors want to run. So the auditors and the publishers should be respectful of those genuine constraints. It's important that publishers explain the roles of the account team and of any third parties that may be involved in the resolution of audit findings. So, for example, the resellers and how audit findings might be fulfilled at the end of the audit. Also, sometimes publishers will take the view that the account team should sit outside the process, that new purchases should be frozen during the course of the audit, and so on. It's important that all of that is explained adequately to the customer on the way in. I said that we sought to treat in-house auditors and external auditors in the same vein. So just as an external auditor should restrict the information received, so an in-house auditor should restrict the information received to the in-house compliance team and not, for example, pass it to the account team so that it might be used for some other sales purpose. And lastly, directly on the publishers must allow the customer proper time to review the factual accuracy of the audit report and give the customer, if you like, a right of reply. Customers must have an opportunity to correct errors and to make points for vendors' consideration. So, for example, accidental deployment of something, other points in mitigation, temporary transfer of migration of product in relation to an IT organization. There may be genuine disagreements about the interpretation of clauses and so on and so on. And it's essential that the customer is given a space to make that point. It doesn't help the publishers either, frankly, if they're unaware of the customer's views. So let's look at the auditors. Some of these are the mirror, if you like, of the obligations on the publisher. But there's a little bit more to it because the auditors are there on site, typically, perhaps less typically at the moment, but in the past have often been on site, and therefore there are some different touch points and different things to control. So data should be collected efficiently, obviously. the basic principle is, so far as possible, to use existing data, and that the auditors, so far as possible, should do take as light touch as possible. So should only use tools and other sort of things to gather or to fill in the gaps in the information already available to the customer. The second one here, auditors should approach software audits as objective finders of fact. There's been some discussion around that in relation to the interpretation of audit clauses. So one of the critical things in this space is that obviously there may be divergent views as between customer and publisher about exactly what the license agreement means. So the auditor has to proceed on one basis or another. And our view from the code's point of view is that the auditor should be entitled to proceed on the basis of the understanding that the publisher has of what its licenses mean, and that interpretation issues should be addressed outside that audit process. But that's an area that there's been much feedback on, and we'll touch on that again at the end. Similarly, with publishers, the auditor should identify a responsible person for the work, who's in charge of the work day to day, and an appropriate escalation point. In fact, if the auditors are regulated, which might happen if it's a Big Four accounting firm or if it's an accountant generally, and other professionals, there may be additional escalation possibilities to a regulator in relation to the auditor's conduct, and that needs to be made clear. Sensitivity to the needs of the customer we've talked about. And on the right-hand side, when auditors collect data through tools and similar techniques, a copy of the data should be provided to the customer. Again, the principle of transparency, it's important that the customer is aware of the information which the auditor is weighing, how they're going about their work and the conclusions they're drawing. And in order to check what the auditor is doing, they need to have access to the same information that the auditor is extracting from their systems so they can challenge it. Auditors need to be able to explain why they're doing what they're doing or why they want to do what they're doing. And one particular topic is around completeness testing and accuracy testing. So there's often a discussion between auditors and customers, particularly around why the auditors want to look at places where the customer is pretty sure the software vendor's product is not being used. And that's because the whole point of an audit is that the auditor checks. It doesn't just take the say-so of the customer. So there has to be some checking that a product isn't where it's not supposed to be. And that's what auditors call completeness testing. There's often debate about that. It's important that the auditors explain why. And if they're prevented in doing that, then they're very clear about limitations in the work that they are able to do. It's obvious that the auditor's report should be clear, accurate, and easily understood. More important, or as importantly, an important part of that is around assumptions. The assumptions should be clearly stated. It is quite often necessary to make assumptions, particularly where it would just take too long and an unreasonable amount of time to get to the last unit of accuracy. And sometimes it's necessary to extrapolate a point or to make an assumption. And those need to be very clearly stated so that the customer can consider whether it agrees or not with those assumptions and extrapolations. We've talked about feedback and mitigation. The point is that it shouldn't be just at the end of the audit. The customer should be kept aware of the conduct of the audit, the progress of the audit, and have a right to feedback during that so that there are no surprises when it sees the final results. Paragraph 87 in the code, auditors should ensure that the reported license position is clearly referenced to the underlying source data. I've seen any number of audit reports that are almost impossible to follow through to the underlying work, and it makes it really difficult to have any sense of the quality of the work done and its robustness if you cannot effectively go from the detail IT environment and what is running and what device all the way through to an effective license position, and a license shortfall or a license surplus. And it's important that reports allow you to do that. Just as it is important that auditors are prepared to explain their findings, particularly as customers may not have the same facility with licensing terms that auditors and the publishers have. Now, I said that it was important that there were obligations in both directions. And so there are obligations that the code proposes for customers. So one of those, paragraph 51 in the draft code, is that customers should accept that resources, time, and effort will be required. And in fact, may be required by people other than the customer's own employees. So for example, if a customer has outsourced service providers, those may well need to be involved to provide information, to extract data from systems, and the outsourcers may wish to charge for that, and therefore the customer will have to pick up an additional bill as a result of the audit. And the customers need to accept that that's going to happen. Customers should not unreasonably withhold data when a reason for it has been given, a good reason has been given. And that's why it's important that the auditor is able to properly explain why it needs to see that. The same sort of thing goes for tools as well. Auditors will often wish to deploy tools, and it's important that sometimes that they need to do so to fill gaps in the customer's own armory of tools that it has available. So it could be a question of an auditor using a command on a particular console to pull back information. It could be the auditor asking for a script to be run across a range of devices. It could be an auditor asking to plug some sort of device in that will do a search across the customer's network. In those cases, the testing that is referred to here is the customer's absolute right to carry out security and other checks and change control checks to make sure that anything that is attached to its network or is run on its network is properly secure and isn't going to cause harm. And auditors, I think, understand that that has to be done, and it's entirely reasonable that customers should have those concerns, but they shouldn't over-egg it, and they should move through those testing procedures as quick as they can. Customers should appoint a project manager, just as the auditor and the publisher need to do so. The customer needs to have a project manager. Some customers, in practical terms, are quite segmented when it comes to their IT infrastructure. And so it's important that the person on the customer side is able to coordinate across a customer's entire estate and not to constantly run up against a brick wall and additional escalations and others needed to get information from further afield. Customers should cooperate with requests for data, provide outputs in a timely manner, provide sufficient access to personnel. All of those things are, if you like, self-evident. The code requires customers to treat the audit seriously as a project and to work to a time plan. And providing access to personnel is an important part of that, but it is a resource consumption, which is why it has to be respectful in terms of the requirements that the auditor asks for. There's been some comment on the first of these here on the left-hand side. Customers should not alter their software usage following the audit notification, but the important point is so as to mislead the publisher or auditor, or the code in detail says, or to present an atypical picture of the customer's use. IT estates are always changing, and the intention here is not about preventing a customer from installing something that needs to be installed for business purposes or uninstalling something that needs to be uninstalled for business purposes. This is about misleading, and essentially the customer is not to mislead the auditor. Customers should inform the publisher of any consultants appointed. Again, there's been a little bit of debate about this. The intention of this relates not to IT service providers and the customer's choice to use its own staff or contractors to do certain aspects of its IT asset management. The focus here is what are so-called audit defense consultants. If the publisher is using someone specifically to respond to the audit and to deal with the auditors, it's helpful if they're identified. And it's by no means always the case that audit defense consultants are unhelpful to the auditors or the publishers. They can be very helpful, but the use of them should be transparent. And then 3 more. Customers are responsible for the information provided by any third parties. It's important that the customer takes accountability for that information and doesn't just walk away and say it's our service provider's fault. And the point about the confidentiality terms is that the publisher and auditor may themselves make information which is confidential available to the customer in execution of the audit, and it's reasonable for that intellectual property to be protected as well, just as steps are taken to protect the customer's intellectual property and data. Completeness and accuracy testing we talked about, and the customers should review the audit report and provide feedback promptly. Good project management. Those are at a very high level and a bit of a scamper through the obligations on the individual parties. The obligations on all parties are pretty self-evident. A project plan, reasonable care to make sure the data is accurate. Everybody to be a little bit pragmatic about incidental data sometimes being collected that doesn't relate to the publisher's programs. There's room for debate on that, of course, but redaction can be very hard on the customer as well as on the publisher and the auditor. So it's a question of just being practical about it, and perhaps the auditor agreeing to remove information before it goes to the publisher. That's quite a common solution. And another important point here is sort of middle at the bottom. All parties should ensure the data shared is used only for the purposes of the audit. And that is important because audits are sometimes commissioned for other purposes, for example, to assess competitor penetration or to facilitate a non-compliance situation for sales. So it's important that audits are used for the purpose for which they're intended, rather than for some surreptitious process in relation to other undisclosed goals. That gives you a quick, as I said, stamp through. I just want to pick up on some of the emerging themes that we've had in terms of feedback. In general terms, I think the feedback has been very positive on all sides. I think it's clear that this has been, people see this as a useful activity. It's something that will help in due course to promote better relationships between vendors and customers. But there's plenty of points of detail. So key themes so far. The need for a sponsoring body. A lot of people have suggested that the code would benefit from being launched under the auspices of a sponsoring body. And I don't disagree with that, but the challenge is which, because it's important that this is an international organization. It's important that it's not a body associated either with the vendors or particularly with customers. So it has to be a neutral thing. And that's harder to achieve than you might think. So there's been some discussion around that, some suggestions made as to which might be appropriate bodies, and we're certainly interested to hear more on that. Following on from that, there's been questions about what I would say the enforceability of the code and sanctions for non-compliance. People have said, well, what's the point of a code if it's not enforceable, if there are no sanctions for not complying? It's very difficult to see how this would work without a sponsoring body, but even with a sponsoring body, it's hard to see how this would really help, because I fear it would just degenerate into a further grounds for disruptive approaches to the audit, which aren't really going to help move the thing along. So we thought it would sit better to remain as a voluntary item. There is a slight caveat to that, and I'd be interested in legal views on this, but if the code is widely adopted and becomes sort of de facto summary of best practice or reasonable market practice, then I expect that it might be referenced by either party and used as a comparison point for the behavior of a customer or the behavior of a vendor or the behavior of an auditor. And in that respect, it might have some theoretical value as a benchmark. But that's, again, an area for discussion. Provision of entitlement records, we talked about that at the beginning. I've said that the code requires that entitlement records should be provided upfront so far as possible. Comments have come in on two aspects, really, whether it's wise from the vendor's perspective and whether it's possible. In terms of wisdom, as I said before, I think transparency requires this as best the vendor can. It's a bit like a bank saying, we'll tell you your bank transactions, but we won't tell you your balance. Or increasing your overdraft, but not telling you what it is. It is really important that a customer understands the limits of the use it is entitled to make of software. The problem is that it's not that easy because the software vendors will have records of what they've sold, for sure, and indeed the customers will have records of what they bought. But there may well have been M&A transactions and other sorts of event that have disturbed that, so that it's not actually easy for the publisher to say with certainty, this is precisely what you're entitled to use. And it is something that needs a bit more of a collaborative approach between the two sides. But it is something that should be done at the beginning of an audit, in our view. Another point of feedback was a comment that we had said relatively little about cloud and software as a service. I think that's a fair point. And we will be looking at saying a little bit more about that. Some people have suggested that in a cloud world, there will be no need for compliance. I don't believe that to be the case. There is still things to trust in a cloud model, and it's trust that means an audit is necessary. So, for example, there may be terms that restrict use of software, even in a cloud context, to particular entities, particular purposes, and so on and so on. And those probably can't be policed by the publisher from its own information and records, and it needs some sort of inspection and audit right. There's other sort of circumstances too. So I don't think cloud will mean the end of audits. The interpretation of license terms has led to a lot of discussion too. Our view is that auditors ought to have a view of what licenses mean, or have to have a view on what licenses mean in order to do their job. And the position we've taken in the code is that it's reasonable for the auditors to apply the interpretations which their client, the software vendor, tells them should apply. And the reason we've reached that view is because audits are not a dispute resolution mechanism, except in very rare cases where the audit clause says so. Very unusual in software. Audits really are a fact-finding mechanism to find out what is actually being done and to measure that and to provide that information back to the publisher and indeed to the customer. If there is a dispute about what the licenses mean, then the customer and the publisher need to take that up between them. And I've even been in situations where the auditors proceeded to collect information on both interpretations so that, if you like, the significance of the difference can be properly appreciated so that the customer and the publisher can have a proper discussion on it with a sense of the value at stake. Again, it'd be interesting to get more views on this and perhaps some thought about whether this changes whether or not the auditors are expressed as being independent, for example. And then lastly, the settlement phase, much discussion as to whether we should have covered the settlement phase. We don't see any easy reference way to do that. Essentially, trying to put a limit on the way in which two parties can negotiate a commercial settlement. It is true that that phase is very often the source of relationship fragmentation and difficulty, but at the moment we've decided that's too difficult to tackle, frankly. So by way of close, where are we? So the draft code is out there. It's been out there now for about 3 months. Feedback is coming in. We are very keen to have feedback on all aspects of it, the detail and on the principles. We're also keen to assemble a small group of volunteers to look at the feedback that we receive and to help us work up the next iteration of this, which we'd like to be sometime in the autumn. And then we'll put out a revised draft and see whether that starts to meet the expectations and needs of both parties in a way that means they can consider taking it up. So let me stop there. That's a lot of talking. I hope that's given you a good high-level view. I welcome questions, thoughts, challenge, as much as you like.
Thank you very much, David, for this excellent presentation. I would just like to ask everybody to post their questions in the chat. During David's presentation, there was only one observation from John Mitchell. I don't know if, John, you would like to take the floor, or else I will raise the question on your behalf. Okay, in essence, John, okay, don't have it. So does the Federation Against Software Theft still exist? And if yes, have they been involved in this code? This is John's question.
So can you say it again? Has the Federation Against Software Theft, FAST?
Yeah.
I think FAST still exists. FAST itself hasn't been directly involved, although I think people with some connection with FAST, have contributed some thoughts from time to time in conversations. But they haven't been directly involved in the drafting of this at all.
Okay. Then there is a question from Kylie. How do you propose to drive adoption if there is no body to take ownership of this?
Good question. So I think adoption will come from a number of different ways, I think. So if customers feel that it would be useful for them, then I think they should ask for it. I hope that there might be some request by customers of vendors that they would like to see the vendors adopting the code. I think also that I'm hopeful that perhaps one or more vendors might decide that this is a reasonable thing to offer customers. But at the moment, my hope was that getting enough conversation going and enough engagement from vendors and customers, we would start to develop a sort of groundswell of opinion in favor of documenting best practice in this way, and that would slowly start to permeate over the next year or two. I think it will take some time, and I think it will be probably a slow start, but I am optimistic that there are some vendors who would like to see this rolled out there because they have an interest in the betterment, the better conduct of audits and this environment. And I think everybody recognizes in the industry that the vast majority of customers and publishers are just trying to do the right thing and to behave professionally. but there is a small number of participants on both sides, and they do amongst the auditors, that can take extreme positions and cause harm, I think, to the market as a whole. It's one of the reasons why I think it is in the interests of all the market participants to stand together in the middle and say, this is what we find acceptable, and to be clear about what is not acceptable. And I think there are real benefits to each customer and to each publisher of doing so. So I'm hopeful that people will find it a good topic for discussion. I expect to find it discussed at kickoff meetings, and I think it'll slowly work its way out there. But I can't say that there's any way of driving a mandate for it at this point. Honest answer.
We have also a question from MN. As with other standards, why not have ISO Geneva, the sponsoring body?
Sorry, say again, why not?
Why not have ISO? ISO as body, as the sponsoring body?
I think it's a slightly different thing from the ISO standards, this. I'm not sure it works terribly well as a standard. I did have a conversation with somebody recently that has been suggested before, and the view was that it was slightly outside the way in which the standards operate and the sort of thing that they would necessarily, that they would contemplate. Other suggestions have been WIPO and various other bodies of that sort. At the moment, nobody's made a compelling case for any of them. But I am interested in arguments and introductions to these bodies to see what they might contemplate. But at the moment, ISO, the indication I've got in relation to ISO is that it doesn't really make, it's not the right answer.
There is also an observation in the chat from Martin Thompson. I don't know, Martin, if you want to unmute yourself and take the floor. Martin says, I think the code should be cloud ready and future proofed. I don't see this being a huge departure from what you have built already. So I don't know if Martin, you want to elaborate further on the observation you made. I guess not.
Well, hi, Martin. I mean, I think the cloud side of things is I think it's entirely fair that that's a bit undercooked in the draft as it is at the moment. So that needs to be more fully addressed over the next 2 or 3 months, and in the next draft it will be. So I think that's an entirely fair point. Clearly the landscape is changing. I mean, it'll always continue to evolve, and the code will continue to evolve as that landscape moves. But there is not enough in there about the cloud, so we will add more in.
Okay, I don't see any other questions in the chat. I would just like to raise one myself. In relation to effective license position and software asset management, it does assist practically, at least my experience, to always have a software asset management tool in order to have an effective license position, have the different versions, and it's part of creating an effective license position, a good software asset management tool. Do you know from your experience, David, if this can be established also without software asset management in place? If there are other ways of somehow tracking and registering and creating an effective license position for the company and its clients, that of course this doesn't go to the audit, it's more how do you apply countermeasures, but if from your experience you can just
Sure.
give us a highlight, I would.
So I would say that historically, many audits, the vast majority of audits over time, took place really without there being good asset management tools in place at customers. So in the early days, and indeed not that long ago, it was necessary for auditors to run scripts or to assemble quite a lot of information from disparate sources, and that could be antivirus sources, it could be configuration management databases, it could be from Active Directory and all sorts of other places you might collate data from to create a picture of the overall licensing position, depending on what sort of license metrics they were and what sort of products you're talking about. The job has changed as asset management tools have got better and better. And they are now, some of them very good indeed. And some of them are endorsed by the software vendors as providing a good answer to the effective license position. But it's still quite often the case that when you look at a customer, either on behalf of a vendor or on behalf of the customer itself, that the tools may not have been completely perfectly configured. The tools may not have been fully rolled out. So you may find that there are pockets of license use which are not recorded by the tools. You may find that the tools are misreading information and so on. So it remains the case, and I think has always been the case, that even with good tools, you need people involved who understand software licensing. And to my mind, that's the more important. If you had to choose between tools and people with really good understanding, you go for people with good understanding because they can compensate for the lack of tools. But good tools without good understanding are actually almost more dangerous. So it's that software knowledge and understanding which is really important, and it can compensate for weak tools, and because there are other ways of working around in most cases.
Thank you very much, David. I don't see any other questions. So at this stage, I would like to thank you very much for your presentation. Thank all the attendees for attending. I would like also to remind everybody for our next event in September, Computers, the Enduring Error Output equals Truth. That will be our next event. And I would also like to greet everybody also on behalf of Santa Silva, our chair. So thank you very much. David, the last word to you. And I really thank you that you were together with us today.
Thank you, Jota. Thanks very much for this. And it's delighted that we managed to get the sort of the ITAM community together with the legal community, because I think this is right at the heart of those two communities. It's a really interesting crossover. And I think neither side sees the whole position. And I think it's really important to have the two together and the two perspectives together. So that's been really good to hear. And thank you for the feedback. And please do reach out, drop me an email. I'm very interested in all views on this and to how we can make this better and raise take up of it. So thank you very much. And thank you, BCS.